Hi, I'm Taichi Okamura. I'm a Japanese IP attorney specializing in trademarks and designs. I started my own IP firm, brandesign, 6 years ago, and around the same time, I also started making YouTube videos and a podcast about trademarks. Recently, I created a radio drama based on a real trademark lawsuit, the Zoom case, and I actually played all the characters myself in Japanese. This time, I translated the script into English, so let's give it a listen.
I'm a lawyer who specializes in corporate law. Lately, most of my work involves intellectual property, trademarks, copyright, that sort of thing. In Japan, many people feel a certain resistance to filing a lawsuit. I don't want this to become a legal matter. I'd rather settle things quietly. I understand that instinct perfectly, but litigation is one of the tools available when a dispute between parties has reached a dead end, a way to move things forward toward resolution. When it's necessary to protect your interests, it should be used. The client who came to my office this time was the president of Zoom Corporation, a manufacturer of audio equipment.
Attorney Soma, thank you for seeing me today.
I've reviewed the materials. This concerns Zoom video communications, correct?
Yes, we've been receiving inquiries about the video conferencing Zoom, things like, I can't join a meeting or I want to cancel my account.
Inquiries that have nothing to do with your company.
Exactly. We're an audio equipment manufacturer. Recorders, microphones, headphones. We work with sound.
Your company was founded in 1983?
That's right. We're not a flashy company, but we've worked steadily day after day. We've spared no effort when it comes to sound quality. As a result, our products have earned a strong reputation among audio professionals, radio broadcasters, musicians, and the like.
Do your products carry the Zoom name?
Yes, the logo appears on both the products and the packaging. So, honestly, having someone else use the same name is a real problem for us. But they're a global service. Will they even take us seriously?
Sending a cease and desist letter is possible. However, there are some concerns.
Concerns?
Your registered trademark is not a plain word. Zoom in standard letters, but a stylized logo. They will likely argue that the logo, at first glance, cannot be read as Zoom.
But our company name is Zoom Corporation, and customers who see our products read it as Zoom.
I agree. Moreover, your website uses Zoom as text, and the corporate name is written in katakana as Kabushiki Gaisha Zoom. Arguing that the logo in isolation is unreadable is detached from how the mark is actually used in commerce.
Then please send the letter.
Understood. Though I should warn you, this case may not end with negotiation.
That's fine. We have no intention of simply handing over this name.
Excuse me. Are you Mr. Matsumoto, Roberto Matsumoto from headquarters?
That's me. Just call me Roberto. I'm from the legal and IP department at U.S. headquarters.
I'm Ono from the Japan subsidiary. Nice to meet you. I have to say, your Japanese is more natural than I expected.
What do you mean, more than expected?
Oh, well, since you're from headquarters, I was worried the meetings would be entirely in English. I've been getting by mostly on vibes.
You have not been getting by on vibes. You okay, man?
Sorry, but you speak really casually, don't you? I was a little relieved when the first thing out of your mouth was so relaxed.
I'm second-generation Japanese American. I lived in Japan for a long time as a kid. It just stuck.
Oh, thank goodness. I was so nervous. I thought someone from the heart of American corporate culture was going to march in.
What does that even mean? I'm still very much from headquarters.
Oh, right. Here's the cease and desist letter, by the way. The other party is Zoom Corporation, an audio equipment manufacturer. They hold a prior trademark registration for Zoom in Japan.
I know. But right now, worldwide, when people say Zoom, they mean us. We can't afford to be stopped in Japan.
They do have the trademark rights, but do you think we can win?
First things first, negotiations. Can you actually read their logo as Zoom at a glance? That's where we start chipping away.
I see. That's reassuring.
Thank you for making time for us today. I represent Zoom Corporation, and I'm here to discuss your use of the Zoom mark.
Likewise. But let me say up front, worldwide, when people say Zoom, they mean our service.
That is not a justification for ignoring our trademark.
We're not ignoring it. But your registered trademark, it's a logo, right? The real question is whether someone can look at it and immediately read it as Zoom.
They can. The component letters are ZOOM.
That's exactly what we're disputing. The two middle letters in particular, the O's are connected. They look almost like an infinity symbol, or an hourglass turned on its side. It's quite different from a standard Zoom in ordinary typeface.
We've been manufacturing products under that logo for decades. Our customers read it as Zoom.
Some people might, sure. But whether the general public reads it as Zoom at first glance, that's a different question.
Your argument ignores actual commercial practice. My client uses the word Zoom in text on their website. The company name itself is Zoom Corporation. Viewing the logo in isolation, stripped of all context, runs counter to established precedent.
Fair enough on the logo point. Let's set that aside for a moment. But the nature of your businesses is completely different, isn't it? You make audio hardware. We provide a communications service, video conferencing.
Different businesses or not, we are receiving real inquiries. And there's something else I'm even more worried about.
What's that?
Your video conferencing service has a recording function, doesn't it? Audio from meetings gets saved, sound quality gets compared. If people start saying Zoom's audio is bad, they might think it's our products that have bad audio.
You're saying our audio quality is bad. That's a bit much, don't you think?
It's a hypothetical. We have spent decades working to improve sound quality. With every product, we listen to our users and built something that works in the field. That reputation could be damaged by the perception of another service.
Roberto, you mentioned different business areas, but my client's registered trademark, in terms of the scope of rights, covers software for computers, which includes your video conferencing software. The registration documents list computer programs, don't they?
But the actual business activities are totally different, aren't they? If you're just going by paperwork and not reality, then it's whoever files first wins, isn't it? That's unheard of in the States.
In Japan, that is generally how the system works.
Ah, yes. The land of form over substance.
Now, you listen here.
If a negotiated resolution proves difficult, we will consider litigation.
Go right ahead. We'll see you in court.
Roberto, the complaint has arrived.
Here we go. All right, time to move.
What are we going to do?
First, we keep pushing the argument that the logo can't be read as Zoom. And at the same time, we file non-use cancellation petitions against Zoom Corporation's trademarks.
Non-use cancellations. But they've been using Zoom for years.
Non-use is assessed on a product-by-product basis. What's at issue here is things like computer programs. If they haven't been using the mark for software, we can get those canceled.
I see. So we're trimming their rights?
Exactly. They argued that, in terms of rights, their trademark covers our services. So we go and align those rights with the actual reality.
So then the goods become dissimilar?
You got it. And we're filing 7 cancellation petitions.
7?
There are problem categories beyond just programs. We're going after every registration they hold that they probably aren't actually using, like programs for video conferencing. In a cancellation proceeding, if even one product is shown to be in use, it fails. So we split the petitions. 7 separate filings, 1 per product category.
How did you even think of that? You've been in America this whole time.
Don't underestimate me. I passed the Japanese patent attorney exam, you know.
What? But you were only a kid when you lived in Japan. You don't mean...
The one and only, youngest ever to pass, at 13. Made the news.
Oh, I wasn't born yet, so I wouldn't know if it made the news.
Don't flex your youth at me.
Sorry, but you're a legend in the IP world. People still talk about it.
Of course they do. The record still hasn't been broken. And I've been doing Japanese trademark work at headquarters ever since.
I'm starting to feel like we can sweep this.
What did you think before now? Anyway, honestly, even lawyers don't always know the fine details of non-use cancellation practice. Which product categories to target can make or break the case. That's where a patent attorney earns their keep.
I feel so much better.
So, we're filing 7 non-use cancellation petitions. The proceedings at the JPO will take time, though. So for a while, the litigation itself will focus mainly on the logo argument.
Let us now address the question of how the plaintiff's trademark is perceived. The defendant argues that the plaintiff's trademark is not recognized as Zoom. Is that correct?
Yes. The plaintiff's logo is so heavily stylized that the question is whether someone can read it as Zoom at first glance. That's the core issue.
Logo designs today are increasingly diverse, and even a high degree of stylization does not prevent consumers from reading it as text. Furthermore, based on the plaintiff's actual commercial use, their website, for instance, consumers encounter the word Zoom in text before they even make a purchase. Once they do, they will naturally connect the logo with Zoom.
But here's the thing. Long before the plaintiff's logo existed, Tombow Pencil had a registered trademark for Zoom in standard lettering, didn't they?
What? That can't be...
The plaintiff's logo mark was registered while Tombow's standard lettering Zoom trademark already existed. That fact alone suggests the plaintiff's logo was not simply read as Zoom by the public.
What if it was read as Zoom, and it was registered by mistake?
Counselor, are you serious? You're arguing your own client's trademark is invalid?
Even if it were registered in error, more than 5 years have passed since registration. The exclusion period has lapsed. It can no longer be challenged as invalid. That is what I am saying.
The positions of both parties are understood. Please submit additional arguments and evidence in writing before the next hearing.
Interesting.
Roberto,
Oh no. Get me everything on Tombow Pencil.
everything on Tombow?
All materials related to their Zoom trademark. And set up a meeting.
A meeting? With whom?
Tombow Pencil's IP department. Who else? If we can acquire the trademark rights directly, we're covered.
Now? You want to do this now?
Now. The trial isn't over yet.
The defendant has indicated new evidence and arguments. Please proceed.
Yes. The defendant has acquired, by transfer, the Zoom trademark previously held by Tombow Pencil. Accordingly, our company is now the registered trademark owner of Zoom. Our use of the mark is therefore legitimate as use of a registered trademark.
Hey, what? You can't be serious?
You cannot use a trademark acquired during pending litigation to justify the very conduct at issue.
There's no law that says that. In fact, the Trademark Act expressly contemplates the free transfer of trademark rights.
But an acquisition made solely to gain an advantage in ongoing litigation contradicts the purpose of the trademark transfer system. It is an abuse of rights.
Then please clearly articulate what that purpose is and provide the legal basis for finding abuse of rights.
Isn't this just cheating?
Emotional arguments don't make something illegal.
Very well. Both parties shall submit the required documents before the next hearing. The defendant will provide evidence of the transfer. The plaintiff will set out the basis for their claim of abuse of rights.
Attorney Soma, they got us. Going so far as to acquire the Tombow trademark. I didn't see that coming.
Yes, though we haven't been entirely caught off guard.
What do you mean?
In fact, we had already filed a non-use cancellation petition against Tombow Pencil's Zoom trademark.
Already?
Yes. From the moment you first consulted with me, I identified that an older trademark, one closer to the plain word Zoom, was still on the books. I filed the non-use cancellation in advance, just in case something like this happened.
Attorney Soma, thank you.
Of course, the fact of the transfer itself cannot be ignored, but if that trademark was not in use for the designated goods, their defense will fall apart.
Honestly, their approach, going out and acquiring Tombow's trademark, makes me angry. If we can neutralize that, I trust a fair judgment will follow.
President Sumita, we've received the decision from the Japan Patent Office.
The result?
We won.
Is that so? Thank goodness.
The evidence of use they submitted related to a multifunction pen with a touch stylus. However, the JPO did not accept that as use in connection with computers.
I see. By the way, this cancellation proceeding is separate from the main litigation, isn't it? I wish they could all be handled together. I have to admit I wasn't fully keeping track of it.
I found it difficult to handle on my own as well, so I co-represented with a patent attorney colleague. The case was contested all the way to the Intellectual Property High Court, and we prevailed.
Thank goodness.
The IP High Court paid particular attention to the circumstances under which Tombow's Zoom trademark was originally registered. About 30 years ago, that trademark had received an office action, a refusal, on the grounds that Zoom, as a word describing a zoom or enlargement function, lacked distinctiveness for certain goods.
Zoom just describes a zoom feature, so it's not a proper trademark. That sort of argument.
Exactly. To overcome that refusal, Tombow had amended the application to exclude external peripheral devices for computers, and registration was granted on that basis. So the use of a touch stylus did not count as use in connection with computers, and the mark was found to be non-used.
Well, honestly, I'm not sure I've not followed all of that, but I understand that you fought with everything you had and that the trademark was canceled as a result. I'm deeply grateful.
The trademark we need to protect is still standing, and the other side will now turn to attacking your trademark registrations directly.
The 7 non-use cancellations.
Yes, 2 of them are not critical. We'll focus on the 5 that matter and fight to defend those.
Roberto, we've received the judgment from the IP High Court.
The 7 cancellations?
Yes, 2 of them, the ones we considered unimportant. The other side didn't even submit evidence of use, so those are already canceled. The judgment covers the 5 we actually contested.
And the result?
All 5 of our petitions were rejected.
I see.
They submitted evidence of an iPhone app. The icon displayed Zoom. The court found that constituted use of the Zoom trademark.
When they produced that evidence, I had a bad feeling. But all 5, that's rough.
The Tombow trademark we acquired was canceled on non-use grounds, and we couldn't overturn that at the IP High Court. And now these 5 we filed ourselves. All gone too.
Don't itemize it for me. I'm already stressed.
Even you get stressed?
What did you think I was?
2nd-generation Japanese-American, casual speaker, youngest person ever to pass the patent attorney exam.
I said don't itemize.
Sorry, that was respect, pure respect. I just thought you'd somehow flip this all around.
That's not respect. That's lazy expectations. Look, We lost the non-use proceedings, but the main infringement case isn't over.
The next hearing will probably be the final arguments and then the judgment. What's the plan?
We argue the nature of our use head-on. Class 38, Communication Services.
Class 38 telecommunication services?
Right. What we provide is not simply a software product under Class 9. We connect users with each other and enable real-time audio-visual communication. We use the name Zoom as a mark for a Class 38 communication service.
But users download an app to use it, right? Won't Attorney Soma argue its software use?
That's the whole battle. Think about it. There's almost no online service today that doesn't involve software. If everything delivered through an app automatically becomes Class 9 software, then online banking is software, email is software. Everything falls into Class 9.
My lunch order on Uber Eats would be Class 9 too.
We don't need to classify your lunch order. The point is, the means of delivery and the essential nature of the service are not the same thing.
And on our side, we actually have a Zoom trademark registered under Class 38, don't we?
Exactly. In the US, we submitted actual screenshots of the Zoom website as evidence of use. And it was registered as a Class 38 communication service. Based on that registration, we filed an international application, and it was registered in Japan under Class 38 as well.
So even though Japan recognizes the Class 38 registration, treating our use as Class 9 software in the Japanese litigation is inconsistent.
That's the argument. The international classification is a global standard. It makes no sense to treat the same service as a different product category in Japan alone. We push hard on that.
Though Attorney Soma will probably come back with something like, the US uses a use-based system, Japan uses a registration-based system, so the philosophy is different. Even if the international classification is the same, how individual goods and services are interpreted varies by country. Won't she say that?
Yeah, she will.
I knew it.
If the Class 38 argument alone becomes a back and forth, we need something more.
If the injunction is granted, Zoom wouldn't be able to use that name in Japan at all, right?
That's right. What's on your mind?
Isn't that incredibly bad? If we have to change the name just in Japan now, we're reprinting everything, overhauling the website, that could cost more than any damages award. And Zoom is so famous at this point, the cost of making a new name stick, I can't even imagine.
What did you just say?
I'm sorry, I'm just panicking out loud.
No. Oh no. Good catch.
Wait, was I not about to get told off?
No. You said so famous. Zoom is so famous now that nobody gets confused anymore.
Pardon?
Even if there was a risk of confusion at some point in the past, things are completely different now. Would anyone today, using Zoom for a video conference, think they were using a product from a Japanese audio equipment company called Zoom Corporation?
No, probably not.
An injunction stops present and future conduct. If there's no current likelihood of confusion, a forward-looking injunction can't be granted. We combined that with the Class 38 argument and put it front and center.
But that's the current situation. The past infringement doesn't just disappear, does it?
Damages are for past conduct. In the worst case, if we can keep using the Zoom name by paying damages, that's acceptable.
You're prepared to accept damages?
What we absolutely cannot accept is being ordered to stop using the name Zoom. We can't rebrand in Japan alone.
I see. That's brilliant. You turned my despair into a legal argument.
I'll let the attitude slide this time, because honestly, oh no, this one was thanks to you.
I'm honored to have helped. Roberto?
What?
Youngest ever to pass the exam? That's really not just for show, is it? Truly incredible.
You are absolutely taking the mickey out of me, aren't you?
Today's session will be the final oral arguments. We'll begin with the defendant's position.
The use in question is not used in connection with a Class 9 software product. It is use in connection with a Class 38 communication service, one that enables users to communicate with one another. The class system is a globally harmonized international standard. Our company submitted evidence of Zoom's actual use in the United States and received registration as a Class 38 communication service. Based on that registration, we filed an international application and obtained Class 38 registration in Japan as well. In light of that, treating our use as Class 9 software in this proceeding is simply wrong.
I do not dispute that the international classification provides a globally harmonized framework. However, how individual goods and services are interpreted and how trademark use is evaluated differs by country, based on each country's legal system and practice.
But our Class 38 registration was accepted in Japan too, based on our U.S. registration.
The existence of a registration is a separate matter from whether infringement is established in relation to my client's trademark in this case. Moreover, the U.S. system is grounded in a use-based model. The fact that a registration was granted based on evidence of use in the U.S. does not mean the same interpretation automatically applies under Japan's registration-based system.
Then, let's talk substance. If everything delivered through an app is automatically Class 9 software, then online banking is Class 9. Tapping through the turnstile with your phone's Suica app is Class 9.
And ordering Uber Eats is Class 9 too.
Oh no. The first two examples were enough. It gets the point across. The point is, if everything is Class 9, then the whole purpose of distinguishing between product and service categories becomes meaningless.
I believe that analysis is case by case. The banking analogy is different in nature from the situation here, and frankly, there is genuine doubt as to whether the defendant's service even qualifies as the kind of infrastructure-level communication service that Class 38 contemplates.
Noted. I will rule on this point based on the arguments and evidence submitted by both parties. Now, regarding the defendant's argument based on the fame of their mark.
Even if there was a risk of confusion at some point in the past, circumstances have changed dramatically. Zoom is now extraordinarily well known as a video conferencing service. Today's consumers are able to distinguish the defendant's Zoom from the plaintiff's Zoom audio equipment.
The defendant is seeking to escape liability for trademark infringement on the grounds that they have become famous. But the fact that the defendant infringed my client's trademark in the process of becoming famous does not disappear.
We do not deny that. If the court finds that there was a problem in the past, that should be addressed through damages. But an injunction is a mechanism to stop present and future conduct. If there is no current likelihood of confusion, an injunction cannot be granted.
That can't be right.
To acknowledge infringement while refusing to grant an injunction would hollow out the entire force of trademark rights. And frankly, such reasoning is unprecedented. This is entirely the defendant's own invention.
It simply separates past liability from the prospective necessity of an injunction. Therefore, it is theoretically coherent to say, past infringement is acknowledged, but a present injunction is not warranted. And there are precedents where damages were awarded, but an injunction was denied.
Those involve special circumstances of non-use. They have no application here. The defendant's so-called current consumer perception is one they built by running roughshod over my client's trademark rights.
The positions of both parties are understood. The matter will be decided in the judgment. The judgment is now delivered. The defendant is ordered to pay the plaintiff damages in the amount of 166 million yen. The claim for injunctive relief is dismissed.
The injunction, we avoided it.
Yes.
That can't be.
Attorney Soma,
Roberto, we avoided the injunction.
That's the big one. For the company, being stopped from using the service name would have been devastating.
But infringement was still found.
This isn't a clean win. Past liability remains.
And the plaintiff will almost certainly appeal.
They will. But for now, our argument was accepted in principle. Not every argument, but the key one. At the appellate stage, we'll raise additional arguments too, and fight the damages figure as well.
I guess trademark rights aren't determined just by whether you have a registration or not.
Right. How your rights are structured and how the market actually perceives your mark, those things matter too. So the best approach is to handle everything proactively, in advance.
But headquarters did file the international application and get Japan rights secured. That's more thorough than most companies.
And yet, look at how this played out. We should have consulted local specialists in each country from the start. That's on us. Genuinely.
Attorney Soma, infringement was found?
Yes. The court found, at least for a certain period in the past, that our arguments were accepted. Your trademark was recognized as being read as Zoom. The court also found similarity with the defendant's Zoom mark, and similarity between the goods and services.
Then why was the injunction denied?
That's where Roberto's final argument was accepted. The court found that Zoom for video conferencing has become so widely known that consumers can now distinguish your Zoom from theirs. In other words, past infringement occurred, but there is no current likelihood of confusion. So, damages are awarded, but the injunction is denied. That is the structure of this ruling.
It's frustrating.
Yes, I find it deeply frustrating as well.
We spent decades working on sound quality. We listened to our users, built products that work in the field, and built the Zoom name from the ground up. And then a massive service comes along afterward, spreads that name across the globe, and now says, we're too famous for anyone to confuse us.
This is my own speculation, but the court may have also felt some reluctance to bring a global service to a halt.
I can't let go of what they did with the Tombow trademark either. Going that far, acquiring it mid-litigation. I was shocked. And yet, at the same time, I have to reflect on our own side too. Earlier, before this dispute ever escalated, we should have done something about the plain word Zoom. We should have negotiated with Tombow or made our own move earlier.
You're right. Securing the plain word trademark in advance, not just the logo, is critically important. And important as it is, for a result like this to come from that oversight.
Even so, Attorney Soma, despite how this turned out, I'm glad we went to trial.
What do you mean?
The litigation brought media attention. It continuously made clear to the public that we and the other party are different companies. And the judgment was immediately covered by news sites with headlines like U.S. Zoom ordered to pay 166 million yen for trademark infringement.
For readers, that makes it abundantly clear that the two companies are separate.
Exactly. And some people won't read beyond the headline, others won't fully grasp the details, but in that sense, it meant something. Still, I can't say I'm satisfied.
President Sumita, let's appeal.
Yes, please, I'm counting on you.
The primary goal, securing an injunction, was not achieved. But the case carried real meaning for my client. For reminding me of that, I am grateful to them. Litigation is, after all, one of the tools available when a dispute between parties has reached a dead end, a way to move things forward toward resolution. It is not a game to be won or lost. thinking about the client's interests, deciding when to file, when not to file, and sometimes when to settle once litigation has begun. That is the work. A counsel who never stops thinking about what serves their client best. That is what I aspire to be.
That's it. This is the end of my drama. Thanks for listening. If you enjoyed it, more episodes are coming on YouTube or the podcast. See you next time.
ゆるかわ
エンディングです。ここからはね、日本語でお送りしようと思いますけれども、そうですね。いきなり英語で始まって、ずっと英語だったと思うんですけども、ここからはちょっと日本語なんで、いつも聞いていただいている方はね、リラックスしていただければと思うんですが、まあ、今回のね、ズーム事件、外国の人たち、商標の実務とかやってる方にとっても重要な事件で、まあ、面白いかなと思ったので、ちょっとお試しでですね、英語で、届けたいなというふうに思って、なんとかやってみました。で、ちょっと作り方とかね、気になる方ももしかしたらいるかもしれないので、少しお話ししておくと、まあ一言で言うとすごい大変だったんですけど、まあ AI とかね使っていけるんじゃないかと思ってて、でやってみたんですけど、あんまりうまくいかなくてですね、これもともと日本語のテキストの台本があったというか、まあ、僕が作ったので AI と一緒に作ったので、まあ、それを英訳するっていうことで英語版のその台本も簡単にできたわけですね。でそれを英語の音声で読み上げるっていうで5名ですね、別の声で読み上げてくれっていうのをチャット GPT とかですね、クロードとかでお願いしたんですけども、なんかそれできないみたいで、なんかソフトウェアを紹介されたりとかしてですね、結局ElevenLabs っていうソフトかな、を紹介されて、それで、やりましたね。まあ、若干課金もしましたけども、いろんな声がこう選べるんですね、そこだと、そのサービスだと。でまあ、今回のキャラクターに合ってそうな声を、選んで、当てがってったっていう感じですね。まあ結構面白かったですね、それ自体はね。なんか本当にディレクターみたいな感じがして、まあディレクターなんですけど、はい、なんか一人で5役やってる時はなんか本当に全部自分でやってるんで、なんかあんまディレクター感がないっていうか、勝手にやってる感が強いんですけど、なんかこう人じゃないけどこう結局 AI のボイスなんだと思うんですけど、それでもこう割り当ててやってるとなんかプロデューサー感が出るなっていうふうに思って楽しかったですね。はい。まあそれまではで発声をするまではいいんですけど、これなんていうのかな、まあ一人喋りじゃないじゃないですか。5人いて交互に喋ってったりするわけなので、そういう風にはできないんですよね。それぞれの人物のパートをこう発生させていく。だからまずそれぞれの人物のパートごとに台本を分けて、それぞれの声で発声をさせて、それをまあダウンロードしてですね、保存すると。でそっからが大変で、それをこう台本通りの順番でこう並べ替えていくっていうのをね、これも AI にねお願いしたんですけども、なんか何十時間もかかるから無理だとかね、なんかすぐ値を上げるんで、なんかいろいろ言ったんですけど、いやいや頑張ってよとかね言ってたんですけど、なんかいや無理だとかクレジットがないとかいろいろ言われるんで、もういいやと思って、はい、じゃあ自分でやりますよって言ってやったんですよね。だからもう大変ですよね。台本見ながら一個一個の人物のセリフ一つを切るたびにカットっていうかそうですね、トリミングして、分割するんですね。分割してで、次の話者の分割した音声を持ってきてみたいな、それを繰り返していくみたいな作業、ちょっとこれ伝わってるかわからないんですけど、ロベルトさんが一言目を発した、その後に小野さんがね、一言目を発すると。 でその次にロベルトさんが二言目を発すると、でその次に小野さんが二言目を発すると、これをどんどんね一個一個切って並び替えるという作業をやっていくんですね。もう本当にね何をやってるんだろうと思ったんですけど、まあどうしてもねこれ外国の人にも届けていきたいというか、あとちょっと本当にトライアル的な、これ英語でこういうのやったらどうなるんだろうって興味もあってやってみました。なのでねぜひ外国の代理人ですね、外国の弁理士とか弁護士とかで商標やってる方にねご紹介いただけると嬉しいですし、YouTube ポッドキャストで配信してますのでね、はい、あとはまあ日本の弁理士とかね知財業界の方も英語の勉強がてらね、何度も聞いてみるっていうのもいいんじゃないでしょうかというところですね。はい、全体通してのご感想とかもお待ちしておりますので、ぜひよろしくお願いします。あとシェアですね。最近31のね、回やった時にかなりいろんな方にコメントいただいて X とかで感想をいただいたりとか、署内で共有したとかいう話もいただいて嬉しかったので、まあそういうふうにしていただけるとそうやりがいがあるなというふうに思っております。では来週からはねまた通常会になるかな。まあもしかしたら勉強会久しぶりにやるかもしれないですけども、はい、まあいずれにしてもこういう英語でいきなり始まってみたいなのはしばらくやらないと思いますので、ご安心ください。ちなみに一人で語訳をね英語でやるっていうのも考えたんですけど、さすがにちょっと外国の人に届きにくいかなっていうところと、あとなんか文化とかが違うのでそのリアクション一つとってもなんか変な感じになるかなと思ったんですよね。ちょっとそこはやめた方がいいかなと思って、そういう判断で、今回は、サービスを利用しましたということでございました。ではまた5日の木曜日にお会いしましょう。できれば来週ということでありがとうございました。